Okay, I have the Lenawee Jail 2 device logged into the meeting. The camera on that is off and the microphone is muted. So I'm going to send a request to start the video. You call the jail and ask them to turn on the camera to start the device.
The judge can see that you logged in, but you need to.
You need to start the video and unmute the microphone.
Start the video and unmute the device. Okay. Thank you. Bye.
Can you hear us now?
Yes, we can. Thank you.
Awesome. Where?
Okay, sir, you're Michael Sepulveda?
Yes. Yes, Your Honor.
Okay, 1 second. All right. Okay, we are on the record now in file 23-21462-FC, People versus Michael Sepulveda, and file number 23-21463-FC, People versus Ricardo Sepulveda. We are here today for a pretrial conference in this matter. We are proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Riggs.
Good morning, Judge. May it please the court. My name is Richmond Riggs, P33863. I am an assistant attorney general. I appear on behalf of the people of the state of Michigan in this matter.
Thank you. And Mr. Daly.
James Daly, I'm past the defendant, Michael Spaulding. Excuse me.
And Mr. Gray.
Good morning, Your Honor. May it please the court, Attorney Scott Grable, P53-310 on behalf of Ricardo Sepulveda.
Thank you. And for purposes of the record, Mr. Riggs is here in person. Mr. Daly, Mr. Grable, and Michael and Ricardo Sepulveda are all present by Zoom video conference. So, Mr. Riggs, where do we stand with the case today?
Judge, as counsel's already indicated, it's my understanding that the preliminary exam transcript the preliminary exam was held, the transcript has been ordered. I anticipate that there are some motions that are going to be filed, and we just need to get a pretrial conference date and a trial date.
All right, Mr. Daly, Mr. Grable, are you both in agreement with that?
I am, Your Honor.
I am, Your Honor. Just to let the court know, it could alter the trial date. We'll be filing a motion to sever based on confrontation clause issues. Again, depending on the ruling, Your Honor, that could alter the trial date if the court generates it today.
Okay. How many days, Mr. Riggs, do you think will be needed for a trial?
Judge, I would anticipate it's probably, I would say 6 to 7 trial days.
Mr. Daly, Mr. Grable, do you agree with 6 to 7 days being sufficient time?
I do, Your Honor, but those would be like full trial days. If we're talking full trial days, we can get it done in probably 6 or 7 trial days. I would just set it up for 2 weeks, frankly, Your Honor. That only really gives us like 4.5 days a week.
And Judge, I apologize, I have not practiced in front of you before. Some courts do, they do 4 or 5 hour days, some do full days when we do a trial. What's the court's practice, if I may ask?
So our normal schedule is that Monday we don't conduct trials because we do our civil docket call. I may be able to, depending upon how far out we schedule this, skip that and have a full Monday. So other than that, so Tuesdays, Thursdays, and Fridays would be 9 a.m. to 4:30 p.m. Wednesdays would be 10:30 a.m. to 4:30 p.m.
Otherwise, 9 a.m. to 4:30 p.m.
Correct. So Ms. Clark, if you're there, we're looking for 7 days. We're probably safer just to block off 2 weeks because of the shortened days and everything else. So if you could find us, we'll need 2 full weeks for a trial in this matter.
Okay, Judge.
If we're looking out so far that we have a Monday where there's very little or nothing scheduled, we could include the Monday.
Okay, well, I'm looking into next year. So you could do Tuesday, February 13th, Wednesday, February 14th, February 15th, Thursday, Friday, February 16th. Do you want to use that Monday, the 19th, or just go to Tuesday, the 20th?
If we have that open, I think I would prefer to use that Monday.
Okay, then Monday, the 19th, Tuesday, the 20th, the 21st, 22nd, Friday, the 23rd. That's 10 days. Monday, the 26th, Tuesday, the 27th, Wednesday, the 28th.
All right, so we can start on the 13th. So that would be 9 days if we ran through the 23rd, with the understanding that the 14th and the 21st would both start at 10:30 rather than 9 a.m. Does that sound sufficient for everyone?
Just
I
to be
believe
sure.
so.
Yes, Your Honor.
Okay. So the trial would be February 13th through the 23rd. And we'll do a final pretrial January 31st at 8:15.
Judge, that Monday, Friday, the 19th is President's Day.
Oh, all right. So the courthouse is not open that day.
And the 19th, she's referring to February 19th.
February 19th. So that would be the Monday of week 2. So that cuts a day off. We could, I guess I see 2 options. We could add another day into a 3rd week. Or if we started on the 20th, I presume, Francis, if we started on the 20th, we would have, we would be able to use that Monday, or do we have anything from the 20th to March 1st?
Oh, that's available, Judge.
Okay, so Mr. Riggs, Mr. Daly, Mr. Grable, any preference on which way we handle that? We can add a day, but we'd have to skip Monday, the 19th. Or we can move the trial to the next week, and then we would have, fewer, wouldn't have any days off, so to speak, other than the weekend.
It makes no difference to me, Judge. Frankly, I don't mind a day off during a long trial. So whichever way the court wants to do, it's fine with me.
I have no issue either way, Your Honor, whatever the court prefers.
I'm agreeable, Judge. We'll just have a day off in the middle. So the court's schedule we would commence jury selection on February 13th and then continue on with the schedule with the exception of the 19th, which is President's Day. The court would be closed.
Correct.
Okay.
Then, so I guess we would add Monday, February 26th. If needed.
Yeah, that'd be good. Just to let the court know, I'm looking at my schedule out here. I have a trial, I have another murder trial. I have lots of murder trials, but I have a murder trial scheduled for March 4 to commence. So I am at some point going to be, I will check on that just to make sure if we're actually going to go on that. I'll give them notice that I will be out of, that's down in Wayne County. So I will be leaving from here and heading over there. I'm not sure how much time will be necessary. If I may ask counsel, estimated, do you have any thoughts as far as how many defense witnesses, how much defense time you might be anticipating?
I would anticipate maybe a day or two on our side.
Mr. Daly?
I'd anticipate less than a day on our side.
Okay. All right, so I should be good, Judge.
Okay. All right, so final pretrial on January 31st, trial commencing February 13th and running through February 26th. Court will issue a scheduling order that has those dates as well as some other deadlines relative to jury instructions, proposed voir dire questions, those kinds of things, in an effort to get any issues resolved before we start the trial. So you will get a copy of that in the mail.
Judge, I apologize. I missed the time for the final pretrial.
So that would be 8:15 a.m. So is there anything else that we need to discuss this morning?
Only, Judge, I believe Ms. Tucker was the previous Assistant Attorney General that was on the file. She is no longer with our office, and if the may it please the court, I will be appearing on behalf of the people in these matters.
Okay. If that's everything, then thank you all for your time. Those here by Zoom can go ahead and log out, and thank you, Mr. Riggs.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor. I'll be coming to see you soon, Rick, just so you know.
Okay, thanks, Scott.
I
Have a good day.
appreciate it. You too. Thank you, Rick. Thank you, Your Honor.
Thank you. all four. That's-
Yeah.
Mr. Murphy, please.
Well, I have the stipulated order for the adjournment on Cook, that all the council I'd bring up. And then I'm on Johnny Domshot, which is going to be a plea, I believe. So I'll just be on Zoom for that other one.
Okay. Okay, Mr. Murphy, are you ready to proceed with Mr. Rudnicki?
Your Honor, I guess, could I speak with, I'm sorry, I didn't know who was for the Attorney General's office this morning, but could I speak with him briefly in a
Sure.
breakout?
Yeah, that's Mr. Ayani.
Mr. Ayani, please, if you wouldn't mind.
Give me just a moment. Okay, Mr. Lyons, I don't have Ms. Wise yet for Mr. Fenton's case, so as soon as we have her, we can proceed.
Your Honor, my client has, and I agree, asked me to present the court with a motion/petition to appoint counsel for an interlocutory appeal. I would much rather do that in writing than to do it orally to give the people an opportunity to respond. Is it possible we
Okay.
can just get a date to do that, Judge? It shouldn't take long, really. It's not a very complex motion.
How much time would you need to get it filed?
I get a file in the next week to 10 days.
I can hear it on September 27th if you can.
I can get a file by
Get it
next
filed.
Wednesday. No problem.
Okay, is there anything you want to do on the record then, or?
Your Honor, as the court knows, we had our Walker hearing.
I don't want you to go in, sorry to interrupt, Mr. Lyons, I don't want you to go into everything yet because we don't have the prosecutor here. So if we need to do something on the record, then we need to wait.
Oh, there's nothing of substance, Your Honor, no.
Okay. I'm sorry, if it's not anything other than procedural or scheduling, what was it that you were trying to say when I interrupted you?
Your Honor, I said there's nothing of substance that I need to go into at this point, Judge.
Okay. Anything procedural or anything else that would need to be addressed, or we just need to get that, just need to have that next date?
Sir, just at next date.
Okay, if you want to, we will put that in the book for the 27th then, and if you want to get that filed with notice of hearing, we'll see you back on the 27th.
Okay, same time, Judge, at 8:15?
Correct.
Thank you, Judge. I'll get that filed prayerfully today or tomorrow morning.
Okay, very good.
Thank you, Judge.
All right, Mr. Fenton, you can let the officer that's with you know that you're done with our court for today.
Yes, sir. Thank you.
I'm sorry, Judge, what type of hearing is that gonna be? If I can let Ms. Wise know.
Mr. Lyons is going to file a motion to appoint appellate counsel for an interlocutory appeal.
Okay, all right, I will let her know.
Thank you. Okay, are we ready to go on the record with Mr. Rudnicki's case?
Yes, Your Honor.
All right, we are on the record then in People versus Clint James Rudnicki. It is file 18-18894-F8. Today is the date set for a hearing on a probation violation. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Ianni.
Good morning, Your Honor. Robert Ianni, IANNI, Special Assistant Attorney General on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Rudnicki.
Okay, and Mr. Murphy, where do we stand with Mr. Rudnicki's case today?
Yes, Your Honor. From my understanding, we're here for a violation of probation for Mr. Rudnicki falling behind, not paying his child support payments. That was due to him having a hernia surgery and medical issues. At this time, speaking with Mr. Rudnicki, and quite frankly, from my understanding of the situation, we wanted to continue a not guilty plea for violating probation. Quite frankly, we'll defer to the court on this. I guess we want to ask to set a hearing if the case was to continue. Mr. Rudnicki understands. Again, this was due to him being out medically for not being able to actually earn. Once he was able to actually earn, he started making payments again. He's caught back up. So I guess I'm asking the court if not the violation of probation isn't being dismissed, just to set a hearing, and we'll figure it out before then, I guess, or we'll have the hearing.
Okay, Mr. Ianni, anything you want to add?
However, the court wishes to proceed, Your Honor, we're good with it.
Judge, yesterday I called friend of the court. He did in August, he paid $106 and then $179.15. And then in September, he paid $106 and then $456.19. He right now owes $38,284.83. I'm fine with just continuing him on probation if he keeps paying like that.
Okay.
His discharge is November in this case.
Okay. So you're okay with just dismissing this violation?
Yeah, as long as he keeps making the payments. If that's okay with the AG?
It is.
Okay, so I think, given the circumstances as I understand them, that the appropriate thing to do would be dismiss the violation. It sounds like he got behind due to a medical issue and has made good efforts to get caught back up. So that's what we're looking for. So I will dismiss that violation at this time.
Thank you, Your Honor.
Thank you, Judge.
Okay, thank you all very much. Mr. Rudnicki, you can go ahead and log out then.
Okay, thank you, Your Honor.
Thank you, Mr. Rudnicki. You have a good day.
You too.
Okay, Mr. Murphy, we have Ms. Betts at the jail. Need a breakout session with her.
Yes, briefly, Your Honor, please. Thank you.
Okay, Mr. Wisely, are you there? Mr. Wisely's microphone is not connected yet. As soon as he gets that connected, we will proceed with Mr. Ragliss's case. So Mr. Raglis doesn't have his audio connected either.
Hello?
All right, Mr. Raglis, are you able to hear me?
Yes, I can. I'm sorry, Your Honor. My phone is acting up.
Okay, we're just waiting. Oh, all right, Mr. Wisely, are you there?
Yes, Your Honor. Good morning.
Okay. Give me 1 second here. All right, we are on the record in file 21-2052FH and 22-20686-FH, People versus Kyle Henry Raglis. We are here today for a hearing on an alleged probation violation. We are proceeding today by video conference. Mr. Wisely, do you want to place your appearance on the record?
Yes, Your Honor, Darren Wisely, and I represent Kyle Raglis.
All right, so status of this case is that Mr. Raglis has been arraigned on the alleged probation violations. He had indicated he wanted to hire an attorney to represent him. He's now hired Mr. Wisely. So Mr. Wisely, do you know how Mr. Raglis wants to proceed with the case at this point?
Your Honor, Mr. Raglis would like to enter a plea of not guilty as to both violations at this time.
Okay, so we will continue a not guilty plea for Mr. Raglis. Are we ready to set this for hearing, Mr. Wisely?
Yes, Your Honor, I just got the discovery, so we're ready to set that for a date.
All right, how long do you anticipate needing for a hearing?
I wouldn't need long at all, Your Honor. I'm not sure what the state would have to put on, but I would presume it'd be half hour to an hour.
All right. Ms. Clark, can you find us let's go with 2 hours for a probation violation hearing.
Second, Judge. Tuesday, October 17th at 2:30.
Judge, I won't be at work that week.
Okay, do we have anything the next week, Ms. Clark?
Would you like that backed up to anything?
We can probably do that. I think, yeah, that'd be fine.
Okay, Thursday, October 26th at 1:30.
October 26th at 1:30. Any issues with that date?
No, Your Honor.
I'm assuming a prosecutor is going to be needed. I am showing that we're finishing up a jury trial in your court on that day, Judge.
Who's that jury trial?
It's the Ellenwood case.
Okay.
That would be the one with me and Mr. Brandt. And I think that's going to take every day that we have scheduled.
Yeah. Okay, so Ms. Clark, that one is
Not one, okay.
that one's gonna go, so I don't think using that as a backup date would be.
Sorry.
October 31st. Is that trial still gonna be going on? The Cecil?
What trial?
That one's up in the air because there's no defense counsel on that case right now. So you could probably put it on that date as a backup.
At 9 a.m.
So October 31st at 9?
Yes.
Mr. Wise, does that work for you?
Yes, it does, Your Honor.
All right, so we'll set it for October 31st at 9 a.m.
Your Honor, is that in person?
Yes, that needs to be in person.
Okay, Your Honor, thank you.
Okay, and so October 31st at 9 a.m. Ms. Monahan, thank you for being here today. My understanding is you were subpoenaed. So at this point, I'll just continue your subpoena to the October 31st at 9 a.m. date.
Thank you, Your Honor.
Thank you very much. Anything else we need to address in this case, Ms. Meir or Mr. Wisely?
No, thank you.
Nothing from the defense, Your Honor.
Thank you very much. Then, Mr. Raglis, you can go ahead and log out.
Okay, thank you, Your Honor.
Right, Mr. Murphy, are you ready to proceed with Ms. Betts?
Yes, Your Honor.
Okay, we're on the record then in files 22-21100-FH, 23-21264-FH, and 23-21519-FH, People versus Julia Rand Betts. We are here today for pre-conferences in the cases ending 100 and 264. It's an arraignment in file 23-21519-FH. So first, let me ask the attorneys to place their appearances on the record, beginning with Ms. Meeker.
Phoebe Mayor on behalf of the people.
Matthew Murphy, appearing on behalf of Ms. Betts.
Okay, and Mr. Murphy, with respect to the newer case that's up for arraignment, does Ms. Betts wish to have the information read?
No, Your Honor, we acknowledge receipt of said information, the witness list, and the discovery demand from the prosecution in this matter. We're to ask for a continuation or an entrance of a continuation of a not guilty plea in this matter, and setting this with a pretrial with the other files in this matter. And would also ask if we could address bond in this file and the other files as well.
Well, we've got here a 22 case, so I'm a little hesitant to just set additional pretrials. So,
Your Honor, Ms. Betts was absent for a period of time. The issue that I'm dealing with is the newer case came up, and trying to get an understanding of what we can get worked out with the prosecution. And also Ms. Betts was trying to get entrance into a inpatient rehab facility, which she has, but it's there, under her father's insurance, because she's not covered under CMH here in Lenawee County, but that is in Ohio. So I understand Your Honor's concern with the matter. I do believe the cases will get resolved. Again, I'm trying to get an understanding with the new one, what I can get worked out with the prosecution's office. I do apologize for that not being addressed today, but I was asking, again, the court to just give us maybe another week or two, a few more weeks, and possibly allow her bond to allow her to be released to an inpatient in Ohio. We have put in for her to be screened for drug court. It just hasn't happened yet, Your Honor.
All right, Ms. Meir, anything to address from the people's side?
Yes, Judge. I sent a global plea offer on this case back in March. It would actually have been March 22nd, 2023. That was before Miss Betts absconded, but also when I knew that this new one that's up for arraignment was being investigated. So I did make my offer commensurate with that. But then she absconded, and that offer included not charging this new uttering and publishing. That's no longer the case, but I can update that plea offer that I sent before is still valid. The only addition would be she would have to plead to one felony on this new uttering and publishing. The offer on that is the case ending in 00. It would be to plead to an added count of larceny 1,000 to 20,000. In the file 264, it would be to plead to attempt possession of meth, dismiss all remaining counts, and then she would have to plead as charged in one of her district court files and a dismissal of the other. And that I would not offer HIDA on this just based on her failing to appear and her continued offenses. And then one uttering and publishing on the new one. So I guess I could type it up and resend it to defense, but I did consider all this when I made the offer back in March, and I would object to bond because she's absconded since then.
All right, so we know, have it on the record now what the offer is. I'll set it for a pretrial on October 18th at 8:15 a.m. With the understanding that if the matter's not resolved at that time, I would anticipate setting it for trial at that time. Mr. Coast, was there something you want to say relative to the bond discussion?
I was just going to speak up about the bond, Judge. when she was out, she had the GPS shut off. We also got a warrant for her because of missing drug tests. So, I would be concerned about her leaving state for inpatient treatment.
At this point, Ms. Betts has had warrants for failure to appear, for failing to, for having her remote breath device shut off, or failing to drug test. And so at this point, I don't think it's appropriate to modify her bond. I just at this point don't trust that the things that people say they're going to do, because I've had a chance at that already. Mr. Murphy, if you get something specific arranged and I can be persuaded that it's actually going to happen, I'd be willing to consider that, but I'm not at this point just going to make that modification without knowing more details about the situation.
Yes, Your Honor, understood. I'll file a motion with the appropriate information when I receive that.
All right, so our next date is October 18th at 8:15 a.m.
Yes, Your Honor, my office will do the stipulation order for that date.
All right, if there's nothing else we need to address in this case today, then Ms. Betts, you can let the officer that's with you know that you're done with court for today.
Thank you.
Thank you, Ms. Betts. I'll come visit you at the jail soon, okay, as soon as I can.
Thank you.
Mr. Dagger Margosian, we're calling for Marco Graydon right now. Are you going to need a breakout session?
I'll need a breakout room with him. I have been speaking with Mr. Sneed and we're ready to proceed.
Okay, as soon as they get him in that room, I will put you in a breakout session with him.
Okay.
That's on Graydon. Do you need anything from me on that, Michael? Isaac
No.
didn't
No. Yeah, no, it's just a preview of what's going to happen. We're just going to be asking for a 1-week adjournment for the court. We can actually reach a solution, so.
Okay, just checking.
Yeah, thank you. And then, Your Honor, the only other case I'm on is Alexander McGee, who should be in the waiting room.
All right, so we have Alexander McGee. Audio is not connected on that device.
The audio should be.
Oh, I'm sorry. I apologize, Mr. McGee. I was looking at the wrong person.
You're all right.
Okay, we are on the record then in file 23-21513-FH, People versus Alexander Lee McGee. We are here today for an arraignment. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
B. Mayor, on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. McGee.
Okay, and Mr. Dagger Margosian, does Mr. McGee wish to have the information read?
No, Your Honor, we've actually reached a resolution with the people. We're ready to enter a plea at this time.
Okay, can you go ahead and state the terms of that plea agreement?
Your Honor, Mr. McGee is going to be pleading guilty to count 1 under HIDA, and count 2 will be dismissed. I don't think that will require an amended information.
Okay, Ms. Mears, is that a complete and accurate statement of the plea agreement?
Yes, I believe so.
All right, Mr. McGee, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Your Honor, I'm sorry, if because this is a HIDA, may we go off of YouTube?
And actually, I don't think we can do HIDA on these cases.
It's under the 750 chapter. It's not the driving offense, so it is.
I still don't think it will, but I mean, we can do it and they'll just send it back if we can't at sentencing.
That's fine. It's eligible, I believe. Let me close these blinds real quick.
All right, so Mr. Dagger-Margosian, my understanding of Homes Youth Trainee Act is that the confidentiality provisions don't apply until he's granted HIDA status, which happens at sentencing. So I don't think that would apply to the plea hearing. So Mr. McGee, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Alexander Lee McGee?
Yes, Your Honor.
Mr. McGee, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, reckless driving?
No, Your Honor, I'm sorry. It's plead guilty to count 1, dismiss count 2, count 1 being under HIDA.
Okay, I apologize. So Mr. McGee, then is it your intention to plead guilty today to 3rd degree fleeing a police officer?
Yes, Your Honor.
You can put your hand down if you want. Are you satisfied with Mr. Dagger-Margosian and the advice that he's given?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
Yes, Your Honor.
Do you understand that also requires a mandatory driver's license suspension by the Secretary of State?
Yes, Your Honor.
Other than as we've discussed on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf is sentenced with court. Is that correct, Ms. Muir?
That's correct.
Yes, Your Honor, correct.
All right. Is that also your understanding, Mr. McGee?
Yes, Your Honor.
If the guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at your trial and to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. McGee, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal, not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about July 23rd, 2023 in Cambridge Township, Lenawee County, Michigan, you did commit the offense of 3rd degree fleeing a police officer?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're going to be giving up any and all claims that your plea was given as a result of threats or weren't disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Lee to plead guilty?
No, Your Honor.
No, Your Honor, I just want to make sure Mr. McGee was advised that under this conviction, his driver's license will be suspended by the Secretary of State for a period to be determined by them, not to exceed 5 years.
Okay. All right, Mr. McGee, other than as we've discussed on the record here today, has your attorney promised you any particular sentence or estimated?
I'm sorry, it's breaking up.
Other than as we've talked about on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Dagger Margosian, do you want to establish a factual basis?
Mr. McGee, on July 23rd of this year, you stated that you were in Cambridge Township, Lenawee County, state of Michigan. Yes?
Yes.
And at that time, did you, was there a police officer that was attempting to pull you over?
Yes, sir.
And did that officer have their siren on, lights on?
Yes, sir.
And you knew you were supposed to, you knew that that was a signal for you to pull over, but you did not, correct?
Correct.
Okay. And you attempted to flee from that officer. You increased your speed?
Yes, sir.
Okay. I think I'm satisfied, Your Honor.
Ms. Muir, are the people satisfied?
Yes, the people are satisfied.
Has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Dagger Margosian?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Lee has had full knowledge of his rights. He's had competent counsel. I will we can set sentencing for November 3rd at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. McGee, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do your interview, please be truthful about this offense and about your background.
Okay.
All right, and I am, Mr. McGee, going to place you in a breakout session with Mr. Jones from the probation department so he can get your contact information.
Okay.
Okay, and then Mr. Dagger Margosian, you needed a breakout session with Mr. Great, is that right?
Yes, please, Your Honor.
Mr. Mawad, we can proceed with your motion if you're ready.
Yes, Your Honor.
Okay. We are on record in file 22-20750-FH, People versus Mason Bradley Lindemann. We are here today for a hearing on a motion to withdraw as counsel. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
Phoebe Mayer on behalf of the people.
Elias Muada appearing on behalf of Mason Lindeman.
All right, Mr. Mawad, you filed a motion to withdraw as counsel for Mr. Lindeman. Is there anything you'd like to say with respect to that motion?
Judge, just so I make the record clear, when I took this case over, there were certain things that I needed cooperation with, and I've not been able to get it. I understand, and I'm glad Mr. Koss is on. He's very hard to communicate with. There is a lot of mental health, and he has several warrants in other jurisdictions, including this one. So I just can't help him anymore. I've tried. It's a rarity I file these motions. Mr. Koss may have some more information on him, but I'm hoping the court would allow me to withdraw. I think there's been a breakdown in the attorney-client relationship.
All right, Ms. Muir, anything that the people would like to say with respect to this issue?
Where is Mr. Lindeman?
He, I think, is out. Mr. Koss, I'm not even sure if his tether's working.
When did he get released? I guess I missed that. I thought he was still in jail.
No, he's been out for some time, Ms. Muir. He's been out for
Yeah, actually, he was out, and then he violated, and he ended up doing 14 days in jail.
Right.
Got out. He was back on bond conditions where he's supposed to test, and he missed his August 21st test. I did receive a phone call from him. He said he'd realize there would be a warrant for him, and that he'll turn himself on the warrant when he was ready.
That is kind of,
yeah, I have tried calling him before, but he doesn't return phone calls. And I've heard that he's living in a camper somewhere on US 12, but other than that, I don't have any other information.
Okay. I mean, I know I don't have much of a leg to stand on here, but obviously this is Mr. Lindeman's second attorney. This is an old case. I have victims who really would like to see justice on this. They're very disheartened by the system already, given that Mr. Lindeman's been in and out of jail and they haven't seen anything happen on their case. And it's, all I can do we've been set for trial now twice. I don't know, Judge, whatever you think we can do to expedite this and get our trial date is what I prefer.
At this point, we do have a bench warrant outstanding for Mr. Lindeman based on the recent violation of bond conditions. I don't know that holding Mr. Mawad in the case at this point would do anything to expedite it given the circumstances. So at this point, I will grant Mr. Mawad's motion and allow him to withdraw the case. I do think given the circumstances, there has been a breakdown in that attorney-client relationship in the sense that Mr. Lindeman is clearly not receptive to the advice he's getting from Mr. Mawad. So I'm going to grant that motion, allow Mr. Mawad to withdraw.
appreciate it. Go ahead.
Could we get bond set fairly high upon rearrest? And he's already had the public defenders. I don't know if they can be reappointed or if we need a conflict attorney. I don't know how that works, but anything, Judge, that you can do to help get this expedited so we can get a trial date once he's arrested.
So he's got at the moment on the bench warrant, he has a $50,000 cash bond. Obviously, I would consider his behavior over the course of this case in dealing with bond once he's arrested on that warrant. I don't think I have any ability to appoint a public defender's office for him at this point. I don't think I can do that even if I wanted to. So I can't do that, but we'll certainly address that issue the next time that we see Mr. Lindeman when he is arrested on the bench warrant.
Thank you.
Thank you.
All right. Thank you. If there's nothing else, Mr. Mawad, you can log out.
Okay.
Okay, I have a person here logged in. Your screen name is Samsung SMA7176U. Can you tell me your name?
Carly Frank.
Okay, 1 second. Ms. Frank, I don't think your attorney is logged in right now, so I'm going to place you back in the waiting room until we have your attorney.
Okay, thank you, Your Honor.
Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. Gray?
Your Honor, I am, but maybe it would make sense to be able to approach the bench with Ms. Meir on this.
All right, so for the person that just got your audio connected, your screen name is SV. Can you tell me your name?
Samantha Biddy.
Okay, 1 second. Ms. Biddy, I'm going to place you back in the waiting room for a couple of minutes here.
Okay, thank you.
Judge, she was supposed to be here in person. It said that on her
Okay.
show cause.
All right, I'm trying to deal with another case right now, so let me